Welcome to Dicta, your weekly dose of law school and bar exam info. I'm Carrie Ann.
And I'm Puyan, and we're the co-founders of Vinco. So today we're going to be discussing a very favorite topic of mine, briefing.
Briefing? What's briefing?
Well, that's a good question. Tell us, Professor Stout, what is briefing?
So briefing is the process that you use to prepare for your law school classes. So you read these things called cases, so it's called a case brief. And it's pretty much your notes on the case that you've read, but in a very specific format to help you prepare for class and for the outlining process and for final exams.
So when you're briefing, what are the elements that you're looking for?
So there are a few categories of information in a brief. They can be called different things, so if you're looking at different resources,
Right.
don't be confused by that. But
Yeah.
generally speaking, a good brief will have a section for the facts, the procedural history, the issue, the holding, the rule of law, and then the reasoning. So I guess we should explain what those things mean.
Yeah, so I remember when I was briefing, I would go through the case and I would highlight what I thought the facts were during my first read.
Mm-hmm.
And then I'd get to the end and realize the case wasn't what I thought it was about. And I'd have to go through it and highlight it with a different color because my first set of highlighting was just completely useless because those weren't the pertinent facts. So I learned very quickly not to touch the highlighter until my second read through because I didn't know what the facts were until I really got to the ruling, the holding, and I analyzed the rule.
Yeah, so that's really good advice. And I will say there's sort of different levels of briefing. There's 1L briefing, and then there's 2L and 3L briefing. This is really addressing 1L, basic briefing,
Definitely.
what you really should be doing, best practice. So when you are first starting out, it is really helpful to read the case once through first without really marking it up to get an idea of what's happening.
Yeah.
And you were talking about the facts. So what's important in the facts section are the legally significant facts. And just like Puyan said, you don't know necessarily what's legally significant, meaning what did the court care about, until you get to the end and you see what factors they were relying on.
Yeah.
So you don't want to necessarily jump the gun. What the facts section isn't is just repeating every single thing that the court put in their introductory paragraph.
Yeah, exactly. And I tried to get smart with it and start by reading the end first so I can get a feel for it, but it depends
That's not really the
depends
best.
on how the brief how the case is written in that specific textbook.
Yeah.
So sometimes the digest is really in the middle, sometimes it's in the end, sometimes it's throughout, and you just have to figure it out.
There really isn't a shortcut for that. So the next section is the procedural history section, and you will quickly learn which professors care about this and which professors don't care about this.
Definitely.
But all the procedural history is the legal story of how the case that you're reading got into that court. So I know, for me, I read a lot of Supreme Court cases in my first year of law school, so it was about what happened at the lower courts in order for the case to get there. I had some teachers who never asked a single question about the procedural history, and then in classes like civil procedure, the professors asked a lot. So what was your experience with that?
I mean, yeah, I found that many professors wanted to know the procedural history, and you'll by the second class you'll know because
especially first semester
they'll
one
cold call on you and ask you specifically what's the procedural history. That's the exact question they'll ask, and then you just see deer in headlights stares because people some classmates didn't know that that's something they should have been focusing on, and they just had the rule and the analysis section good to go, but they didn't really realize how the case got where it was. And it oftentimes made a big difference because you'll be reading through a case, and if you don't pay attention to the procedural history, the ruling may not be what you thought it was going to be.
It won't make sense if you don't know what happened below. Right. So I think as an initial matter, you should be over-inclusive in that section.
Definitely.
Just for the sheer fact of not wanting to be embarrassed if you get called on. And also, it will help you as you're sort of learning this whole process to understand what happens in the courts to get the case to the level it's at.
Yeah, also, for what it's worth, procedural history is extremely important for being an attorney because it shows you how the law actually works.
Yes.
So, it really connected a lot of the lines for me between what happened at different court levels, what courts had the authority to do what the standards of review were, and things like that. It really made a big difference for me.
So in the beginning, like I said, you'd want to be over-inclusive, and then we also understand as law students you can be short in time, so if it becomes very obvious that this isn't super important for a particular class, you wouldn't necessarily have to keep including that. So the next part, which is one of the most important parts, is the issue section. So the issue is, what is the question that the court's answering, right? Why do people go to court? They go to court because they have a problem and they want to know who's right and who's wrong. Yeah. And that's what the court does. They decide that. So the issue is, what is that problem? What's that question? I think that the issue should always be framed as a question, and then your holding, which is the next part, would be framed as the answer to that question.
Yeah, what I found complicated for me was when there are issues within issues. So there's like main issue and then two sub-issues and then another main issue. And now, like, as a practicing attorney, I deal with this all the time, where you'll read precedent cases or cases on appeal, decisions of cases that went to appeal, and the court is answering several different issues. Yeah. And sometimes they won't even get to the main issue because, like, there was a previous issue that, and they just relied on that and said, you know, since we find that this previous issue was not relevant, the whole case is moot now. So they don't even get to the main issue that you want them to answer.
So in a lot of your first year classes, that won't be the case because they pick single issue cases. They're edited for your case book. Right. You're not finding them on the internet. So that is, you run into that a little bit less, but you definitely could run into cases that have more than one issue. Yeah. And in that case, I recommend separating them. But how you craft your issue is really important, because you don't want it to be so narrow, so fact-specific, that the answer to that question would only be relevant to the case before you. Because that doesn't really serve the purpose of the courts, right? The purpose is that if another case with similar facts were to come before a court, that they would know how it should come out based on the previous case law. So if your answer to your question is only going to be useful to this specific case, it's probably too narrow. So you want to make sure that it's not too narrow. You also want to make sure it's not too broad. For example, in my first year contracts course, every single issue that I wrote on every single brief was the issue is whether there's a contract. That was not the issue in every case. You want to be looking at the elements. So, for example, sticking with contracts, really I would have been better served with issues like the issue is whether there was acceptance. The issue is whether there was consideration.
I had the same problem, and I'm really still to this day not exactly certain how I could have analyzed the situation differently, because I had the same, I would ask, the issue is whether there's a contract, or the issue is whether there was understanding, like there was a meeting of the minds, and just I kept it too general, and I just wasn't grasping the more specific issues until I just became more familiar with the subject matter.
Yeah, I think it has to sort of do with reviewing as you go, which is a topic for another class, but really kind of understanding that there are doctrines, so contract formation, which is the issue is whether there's a contract. Contract formation is its own doctrine, which has elements. Right? Acceptance, consideration, offer, not in order. Don't write any of that down. But understanding that those elements, then you're looking, well, where's the issue with one of those elements? Not the broad doctrine question, but the issue is going to be with one of the elements. And that's really what finally clicked for me, which I was doing in torts, but it never happened for me in contracts.
Something that would have helped me a lot, and I don't want to keep going back to this, but in your crush offer, you said go through the table of contents, right? And that would have helped me a lot with framing the issues, because if I knew where, like, what I should be paying attention for, like if this subject or this case is under the subheading of unilateral contracts or whatever, I would have known the issue I'm looking for pertains to a unilateral contract, and I often did not pay attention.
That's a really good tip. I actually recommend to most of my students who come to me for questions about briefing to write on the top of their brief what the subject matter is, so that they can place it within their semester.
Yeah.
So that's a really good thing to do, using the table of contents. And to get that document that Puyon was talking about, I created a guide called Crush that's to help you prepare for your final exams. It's a little outside the scope of briefing, but apparently there's some tips in there that Puyon would have found useful. So you can get that at bit.ly/crush offer. So to move back into talking about the issue and holding, I think we've covered the issue. The holding is really just answering that question. So if the issue is whether you have acceptance when, fill in the facts, the answer would be yes or no, repeat the facts, right? So really, if you screw up the issue, you're going to screw up your holding. Yeah. So they're really, you have to work on that issue part first. Then the next part is the rule of law. So that's the thing that you're going to come back to when it's time to start breaking down information and preparing for finals. And you're going to pull out and say, okay, this is one of my rules. You're going to have a ton of them for every class, and this is one of them. So you want to make sure that you pull out that rule of law that the court applied to. So that is some sort of test that has factors or elements to it that they used to apply the facts to.
Sounds good. I would oftentimes make my rule way too narrow. So I would have like a general statement, and then I would have a ton of qualifying statements, because those were the facts in that case. Right. But I really needed to step back, and I didn't realize that until later on, toward the end of my 2L year. Finding that right balance between too broad and too narrow. Exactly.
So that leaves us with just the reasoning section, which I know is the most important part of your brief. This is the part of your brief where you write down why. You answer the question, why did the court hold the way they did?
Yeah.
Why did they reach the conclusion that they did? And this is so important for a few reasons. One, this is where your professors are going to spend the most time asking you questions.
Yeah.
They expect that you can tell them what happened in the case, that you can regurgitate the procedural history, that you can pull out the rule of law, right? These things typically aren't like super hidden within the case.
Yeah.
But what they want to see is your ability to think critically and to understand, to do critical reading, and to understand why the court came out the way they did. And I say that this is super important because it directly correlates to writing your final exam essays. And that's also a topic for another video. But your ability to answer that question, why, will haunt you all through your law school career. So if you are consistently finding that your reasoning section doesn't match up with your professors, I strongly encourage you to reach out for help with that skill sooner rather than later.
Yeah, I completely agree with everything you said.
And it's on tape.
I was struggling a little bit with my reasoning sections at first, and at some point it just clicked for me, but I know other people sought additional assistance and they eventually got it. But it's just like, before you graduate, before you begin to think about any bar exam, you need to be able to do reasoning analysis, that whole section.
Yeah. So those are the essential elements of a brief. Again, your professor might tell you they want something else or something different, and you should listen to them because they are the judge of your class. And I will leave you with this final bonus tip. Briefs are meant to be brief. So I think a brief that is over 1 page long is too long. It won't help you with class. You'll pretty much just be rereading from the case at that point, and it will make your breaking down outlining process so overwhelming.
My only exception to that, and this is just my
common law cases?
No, if the facts are overwhelming, sometimes the procedural history and facts are just so long and complicated that could take up the majority of your page. That's just my opinion. Yeah, again, that there's exceptions to every rule that we tell you here, and exceptions to every rule in life. But as a general matter, if you are having 2-3 page briefs, you want to look at what you're doing. Yeah. Because that's not you putting things in your own words and understanding. It's you copying over the case into little categories, and that wouldn't be helpful in most cases. Exactly. So we hope that this helps you put yourself on the right track for briefing and preparing for class, and we hope to see you back here next week.